Hi, I thought since that we didn't have people show up for the study session this afternoon, I thought I would just do a quick video that walks you through the expectations for the exam, and then it also talks about the questions for the exam. Okay, so on the Canvas site is the midterm information. And so make sure that you read that because that's where you're going to find information about what my expectations are. But in summary, so the exam itself is an essay exam that you've received those questions today at midnight, and that there are 6 questions on that exam, and you will be answering 4 of those questions. It's essay questions. It's take home, obviously. It's open book, open notes, open resources. And so you have some time to work on the exam. The exam is due Saturday, March 19th at 11:59 p.m. And so my expectations for the exam are relatively high. You have a lot of time to work on it, and you can develop your ideas, and you can bring to bear course material for support. You can also reread it and proofread it to make sure that it is of high quality. The exam itself is worth 150 points, which is 15% of your overall grade. Once you take the midterm exam, right now we have about 200 points. This will bring us up to 350 points. So there's still a lot of points left after the midterm exam. Hopefully you'll do great on the exam, but if you fall short and you don't do as well as you wanted to, there's still a lot of points left for you to actually still do really well in the course. So just keep that in mind. Don't freak out if you get a lower grade than you wanted to, but hopefully that won't happen. Once you submit the exam, then we have spring break, and hopefully you'll find some time to relax. Now, one of the questions that my students often ask me is, well, one, what material is covered? So it's everything from topic 1 until topic 6, so the first half of the course material. Another thing that students ask me is, how long should the exam be? And so the exam should be, about 8 pages double spaced. And so that means 2 pages for each question. You answer 4 questions, it should be about 2 pages per question. A little bit less than that's okay, but anything a lot less than 1 page is probably not going to be enough. I mean, you're going to want to develop your ideas. You're going to want to show evidence that you understand the course material. So it'd probably be pretty difficult to do that in one question, in 1 page. A little bit over 8's okay, but if you're getting to 10, 12, you don't need to tell me everything you know about civil liberties, okay? You'll want to answer the prompts in the question. And so make sure that you're narrow and focused on answering those questions. Don't go beyond the prompts. It's not necessary, but make sure you answer all of them. So about 8 pages double spaced. That when it comes to the citations, that I'm not expecting you to use outside course materials, that's not necessary. Everything you need to answer these questions, you have the textbook, the lectures, course commentary, any articles, okay? And so the best exams won't just focus just on the lectures or just on the textbook or just on the case excerpts. You'll want to bring all of that to bear, right? So the best answers will use information from the lectures and from the textbook, okay? That if you're using a concept that's directly from the textbook or lectures, you're going to want to cite those. And so you'll just want to say, rights, liberties, and justice, and give a page number, or like lecture 5 or topic 5, lecture 1, and cite that. That you don't need a works cited page because you're only using material from this course, okay? If you do use a verbatim quote, make sure that you put it in quotations with the page number. That if you don't, that's considered plagiarism, and that is a bad thing. So any direct quotes need to be in quotations. And also keep in mind that, be judicious in your use of quotes. I'm not assessing your ability to cut and paste excerpts from the textbook into your exam. I'm assessing your ability to understand the material. So, it's okay to use a couple of quotes, but make sure you're translating this information into your own words so I know that you understand what you're talking about. All right, so that's a general overview of the expectations for the exam. Let's go ahead now and take a look at the questions. So let me share my screen. Okay, so here are the questions. Now, that the first thing you should do is that you should title when you open the exam, you should save it to your desktop or a hard drive or a zip drive. Title it maybe with your last name and Paul 210 or something like that. If you had students who haven't saved it and then they submit it, it's a blank document and they've lost all their work. So make sure that you save it to your desktop. So there are 4 questions that you choose from out of the 6. I do want you to include the question at the start of each answer, including that won't count against your page total. It's good for you to include it because the prompts are right there. It helps focus your answer. It's also good for me to grade because I've got the question right there and I don't have to keep digging around trying to find the exam. If you are not answering question, you don't have to answer them all. Don't answer them all. Just choose 4. Just skip it, or you can delete the question that you're not answering. So let's go through each of these. The first one has to do with chapter 1, and I've got the page numbers there. I'm asking you the question about the difference between legalism and realism. And so legalism, we spent some time in class talking about that the legalism are those different methods that the Supreme Court uses: stare decisis, pragmatism, polling jurisdictions, original intent. And so you're pretty well versed in that. Realism, we talked a little bit about in class, but it's in the textbook. Realism is looking more at the judicial ideologies, liberal, conservative, activism, the proper role of the court, etc. So in this, I want you to compare and contrast legalism and realism, making sure to summarize the main tenets of these 2 categories. In what ways are legalism and realism similar? How are they different? And explain how these 2 categories overlap. You'll see overlapping between ideology and legal method of interpretation, right? That just is a little hint there. Next of the 2, which do you think comes closest to explaining how the justices actually decide cases? At this point in the semester, we've read a lot of cases. We have a lot more to read after spring break. So you get a good sense of, how justices are answering or are deciding cases. Do they seem to be driven by legal methods of interpretation like original intent or stare decisis, or do they seem driven more by ideologies, or maybe a little of both? There's no right answer to this question. So just explain your answer, give me a good argument, and that support your argument with evidence from the textbook. There is a right or wrong answer between what the difference between legalism and realism is. But when it comes to which do you think comes closest to how the court decides, there's no right answer there. So keep that in mind. The second question has to do with judicial review. And so it says that the Supreme Court declared for itself the power of judicial review in Marbury versus Madison. It is not in the, it's not in the Constitution. That power is not. So first, describe the facts of the case for Marbury, including the question before the court, and then in your own words, define what judicial review is, okay? In the court opinion in Marbury, why does Chief Justice Marshall argue that the court should have this power of judicial review? So in your answer, you're gonna wanna maybe talk a little bit about like how the court resolved that dispute about whether or not Marbury deserves his commissions. But in answering that question, why does Chief Justice Marshall argue the court should have the power of judicial review? There you're going to want to look at the decision of the court, right? And look at Marbury's argumentation for why judicial review is so dang important for a constitutional democracy like that in the United States. So I would expect you to bring a reference to Marshall's decision as examples of that. Do you think it's correct that we need judicial review? And so next I want you to think critically about judicial review. On page 54 in your textbook, there's table 2.1, major controversies over judicial review. And I've actually included that at the end of the questions here. And so there's arguments supporting judicial review. There's arguments opposing judicial review. So what I want you to do is I want you to read all those arguments and I want you to tell me which of these do you think supporting judicial review is the most persuasive and why or compelling, and which opposing a judicial review is most compelling and why. Okay. And so bringing us back here, of the arguments, which do you find most compelling? And then make sure to explain your answer. Okay, there's no right answer, which is most compelling for each of the sides, but make a good argument for that. That's question 2. For question 3 has to do with the incorporation of the Bill of Rights. And so that, as we know, explain how the court has approached the incorporation of the Bill of Rights. Points to consider: did the framers intend the Bill of Rights to apply to the actions of the states? What does the decision in Barron versus Baltimore tell us about incorporation? What role did the 14th Amendment play, the Privileges or Immunities Clause, as well as the Due Process Clause? And then also, what's the importance of Justice Cardozo's opinion in Palco as it relates to incorporation? Finally, the Supreme Court, they've never adhered to a view of complete or total incorporation. In other words, the Supreme Court wasn't like waved a magic wand and said all of the liberties of the Bill of Rights apply immediately to the states. As we know, they went liberty by liberty, selective incorporation. And so what do you think using selective incorporation is the better approach to use for incorporation? If the whole Bill of Rights had been incorporated totally to the states at, let's say, the start of the 20th century, what impact would that have had on individual rights? So in other words, like, what if in 1910, the Supreme Court said every liberty in the Bill of Rights applies to the state henceforth, right? How would that change our attitude about our civil liberties, or would it? So explain your answer using specific references to course material for support. 4 has to do with how the court has defined religion. We know that they moved from a very narrow definition of religion to a very broad definition of religion. And so talk specifically about that evolution using Ballard, Seeger, and Welsh to explain that evolution. Why is it important for the court to define religion? And then thinking of the definition the court uses today, do you think this is a good definition? And explain why. 5 has to do with Lemon v. Kurtzman. You got to have a question about the Lemon test. So Lemon v. Kurtzman provides the Supreme Court with one of the most famous 3-pronged tests. First, explain the 3 prongs of the Lemon test and from which cases they originated. We spent a lot of time in lecture with that. There's disagreement over the court, which your textbook talks a lot about the usefulness of the Lemon test. What do you think? Is it an appropriate standard to use in Establishment Clause cases? And the best answer will reference alternatives to the Lemon test that are mentioned in the textbook. Okay. And then for the last one, you get to choose one, either 6A or 6B. And they both have to do with speech. So the first one is about the evolutions of the standard that the courts use to adjudicate freedom of speech. Have a whole lecture dedicated to that. So from Schneck to Brandenburg. And so in your answer, explain why the court has not adhered to a single position, changing standards depending on the circumstances of the case and historical context. Why has the court been more willing to restrict freedom of expression at certain times and has allowed more liberal standards at other times? Are you satisfied with the standard that the court uses today? Why or why not? And explain your answers supporting your explanation with examples from the textbook and from case decisions. Okay. Again, there's no right or wrong answer about whether or not you think that the standard that the court uses today is the right standard. Okay. But just make a good argument. And so make sure that you do sort of describe the different tests that from Schneck to Brandenburg, although you don't have to go into over detail about those, just do a good summary. So you can choose that one, or you can talk about symbolic speech. So first, explain the difference between traditional forms of speech and symbolic speech. Okay. The best answers will provide examples of symbolic speech and address to what degree symbolic speech is protected by the First Amendment, both in the textbook and lecture. Next, compare and contrast the 2 great cases from symbolic speech. The draft card burning case, United States v. O'Brien, and the flag burning case, Texas versus Johnson. Points to consider: in what ways are these cases similar? How are they different? What role do the differences play in helping us understand the way the court ruled in each of these cases? And then I'll just, do you think burning a draft card or burning a flag is essential to the ideas that O'Brien and Johnson wanted to communicate? Could they have communicated those ideas without engaging in symbolic speech? And in other words, to what degree is their ability to express ideas diminished if they are prohibited from burning the draft card or burning the flag? And finally, do you agree with the decisions that the court had in both O'Brien and Johnson? Explain your answer, making sure to briefly summarize the main reasons for the court for why they ruled the way that they did. Okay, so that should be a fun question. You could do the standards 6A, or you could do 6B, which allows you to dig in more deeply on those two very cool cases. Okay, so that's it for me. Hopefully that you'll find that useful. That's what we would have done in the study session. Hopefully you'll find this overview useful as you are working on your exam. Thanks for your time. Appreciate you listening, and I'll talk to you again soon.